The Council of Legal Education is seeking to implement compulsory Tikanga Māori courses for all law students. If it goes through, they will take effect from the 1st of January 2025. It means every first-year law student in New Zealand will be required to take and pass a course in Tikanga Māori. In addition, Tikanga will be infused in all other compulsory subjects, contract law, property law, and so on. Now, up until now, the curriculum for lawyers has been made up of what is described as proper law subjects, such as criminal law, law of torts. Tikanga is a system of beliefs, a system which indicates the way the Māori who subscribe to Tikanga consider is the right way of doing things. Basically, it's concept based around customary practices or principles and covers a wide range of areas. For example, culture, protocols, customs, ethics, etiquette, and law. It is not a law, and by saying it does not make it so. A senior King's Counsel says New Zealanders increasingly believe the country has an activist judiciary, and society will be damaged if Parliament does not block compulsory Tikanga Māori for law students. Gary Judd KC went before Parliament's Regulatory Review Committee on Wednesday, and he joins me now. Gary, good afternoon.
Good afternoon, Leah.
Now, Gary, before we get to the committee, I suppose the first question has to be what our laws would look like, or what our judiciary would look like, if Tikanga Māori was incorporated into laws, as you see it.
Well, for a start, it would lack certainty and consistency. It would be introducing something which is almost infinitely flexible. It would provide a means by which the judges could exercise or utilise their own whims, their own views of the world, their own ideologies to decide cases rather than deciding cases according to established law. Although in some ways there's speculation involved in that, because we don't really know until it happens exactly what will happen. But yeah. I'll give you an example of what I consider to be the right approach to Tikanga aspects. Back in 2011, I think it was, there was a dispute between the widow of a man called Takamore. I think I'm pronouncing his name right, or it might be Takamori, who was Tuhoi, and he had gone to Christchurch, and he had married a Pakeha woman, a Miss Clark, and they had been together for 20 years. They'd had children together. He died, and Tuhoi snatched his body and took it back to the Bay of Plenty. Miss Clark, who was the sole executrix of his will, and therefore the person who, if there was disagreement among the relatives, had the right to make the call, said she wanted the body back. She wanted it buried in Christchurch because that's where he wanted it to be buried. According to what he had told her, it was where his wife and his children were. So Miss Clark went to court, and she, in fact, won in both the High Court and the Court of Appeal. But in the course of the consideration of the issues in that case, both the High Court and the Court of Appeal had to consider whether, in fact, there was a Tuhoi custom which might perhaps have given them a legal right to to override Miss Clark's wishes and to take the body back to the Bay of Plenty. Now, in fact, what happened was that the there was evidence given about what Tūhoe practices were in this regard, and it was established that there actually were practices which meant that the Tūhoe iwi could insist on one of their own coming back to be buried. But the question then arose as to whether this custom was something which should be enforced as part of New Zealand's common law. And the court, both the High Court and the Court of Appeal, considered the various criteria which had been developed over centuries as to when a custom should be recognised as having legal force. Now, one of the requirements, which was a part of the 5 or 6 or 7 particular criteria, was that the custom must be reasonable. And in the High Court, Justice Fogarty decided that it was not reasonable because New Zealand's common law recognised a system of individual freedom, individual rights, and that Mr. Pakamore had indicated a desire to be buried in Christchurch, and therefore it couldn't be his own views couldn't be overridden by the views of Tūhoe. In the Court of Appeal, took a different tack. It still said that the custom was unreasonable, but they said the Court of Appeal judges, or the two of judges in the majority, said that the custom was unreasonable because it involved the notion that it was permissible for force to be used to implement the custom. And the Court of Appeal majority said that in our world, in modern New Zealand today, might is subordinate to right. We are a society where rights are important and force is not the way in which we do things. So the Court of Appeal said the custom was unreasonable, and as a consequence it was not part of New Zealand's common law, and they said that Ms. Clark was entitled to have her husband's body taken back to Christchurch.
Right,
to be buried.
Gary, I've got a few questions to get through, so we might have to wrap this one up quickly. Yeah. So what you're saying is, in that particular case, if Tikanga Māori law was to be incorporated, that case may have been different, possibly.
Yes, and the irony is that the judge who delivered that Court of Appeal judgment, 11 years ago, was Justice Glazebrook. And today, in the most recent case, she took a totally different tack. She said that because the rules for recognising customs could not apply, or that tikanga could not survive those rules, that tikanga was inconsistent with those rules, therefore those rules were wrong, and effectively she and the two other judges in the majority in that case in the Supreme Court said that these rules as to when customs were to be recognised as law were no longer to apply in New Zealand.
Gary, can I ask you though, if this is an attempt by what you have called an activist judiciary that wants to ramrod tikanga into our laws, who's actually benefiting from this?
Well, it's a very good question. One that's strange enough, I've just been thinking about in recent minutes because of an email that someone sent me. I actually don't think that anyone is benefiting from this. There might be some Māori people who think they are benefiting from it, but in fact they are not, because this sort of mentality is one which subordinates the individual to the tribe, and it means that instead of thinking for yourself, you actually think the way in which the tribe tells you to think.
But are there judges? Are there judges out there, Gary, that want this? Do they think this is think this is important?
Yes, there are, and we know this because they have said so in their extrajudicial writings or speakings. That means to say not as part of decisions in particular cases, but what they've said in speeches and written in articles. And there are two who have been particularly strident, two Supreme Court judges who have been particularly strident in this area. One is Justice Laysbrook, whom I've just mentioned, and she is an adherent of decolonisation. So she said in a speech she gave in 2021 that until we, I emphasise the we, until we complete the process of decolonisation, there's such and such and such and such. And then in a footnote, she indicated that as a generality, decolonisation meant the Indigenous people taking back power and control. And she said in 2021, in a speech, she said we have made a start on this by recognising tikanga as part of the law and by what we are doing in the law schools. And she instanced an article by her fellow Supreme Court judge, Justice Joe Williams, in which an article entitled Introducing or Cementing Tikanga or something like that, Can We Start with the Law Schools? So in other words,
so made it very clear.
Williams was making it very clear that he wanted the law schools to be infusing
tikanga.
Putting what I think I put it in when I put it to the select committee was that they were co-opting law students to advance this political decolonisation agenda.
Gary, do we ask law students to study the culture of any particular ethnic group in New Zealand?
No,